Hi, I'm Tom Williams. I'm an immigration attorney. I have approximately 25 years of experience just practicing immigration law. I've been practicing law for over 30 years. What I want to do in these videos is to give some general information and address questions that I hear frequently from clients who call. And my intention is to present these videos in a very informal manner. And I will just talk as if you were a client and you were calling me and you were saying, can you please explain to me what an H-1B visa is, what an E-2 visa is, would I qualify, how do I apply for the green card, etc. So let's start. The topic today is going to be application for the green card. Generally speaking, I say it's a three-stage process. The first is what they used to call a labor certification. It's more commonly known now as the PERM application. Second step is the filing of the I-140 or the petition for alien worker. And then the third is the application for adjustment of status. Now, the application for adjustment of status is the actual application for the green card itself. And it's commonly referred to by the form number, which is the I-485. So people will typically say, now we file the application for the labor certification or PERM. Second stage, I say we're ready to file the I-140. And then they will say, okay, can we apply for the I-485 or the 485? And that's what they're talking about. The 485 is the adjustment, the final stage. All right, stage one. Let's talk about the PERM or the labor certification. A labor certification is required in two particular categories. They're called EB2s and EB3s. And the EB stands for employment-based. There are two general categories of applying for the green card, and that is through a family relationship, which would be a family-based case, or through an offer of employment by an American company willing to offer employment and sponsor an individual for work in the United States. So what I focus on in my practice is the employment-based visa applications, and that's what EB stands for. So not the families, but the employment-based categories. There are 5 preference categories in the employment-based visa applications, but for again, the labor certification or the PERM applications, you're talking about the EB2s and the EB3s. And that's the most commonly used expression these days. So they will say, do I qualify for an EB2 or an EB3? Okay. Now, a labor certification or a PERM application. Number one, it is not the same thing as an LCA. I have had people who called me and said, well, I don't need the labor certification because I got it when I applied for my H-1 2 or 3 years ago. And when I ask them what they mean by that, they'll say, well, my company filed an LCA for me. So an LCA comes into play when you're filing for an H-1 visa. A labor certification is what is filed when you're applying for the green card. Now the labor certs are more commonly called PERMs. That eliminates some of the confusion that used to be existent in the old days. Okay. Now, when one is applying for the green card, this application for the PERM or the labor certification is actually not filed with the Immigration Service, but it's filed with the Department of Labor. Definition is that it is the Department of Labor's determination and certification that if the sponsoring American company offers this position to the beneficiary, that he, the beneficiary, will not be taking a job away from a qualified U.S. worker. And that's what the certification process involves, whether or not there is a qualified U.S. worker. So it's a determination whether or not there's a qualified worker. And the Department of Labor has to review all the paperwork, and if there is not a worker who meets all the job requirements for this particular position offered by the employer, then the Department of Labor will issue the labor certification of the PERM application. Okay. Now, what does this mean? it does not, even though the words are labor certification, it is not work authorization. It's got the word labor in there, but it is not work authorization. That's why actually I prefer, I'm glad they went to the PERM phrasing because there's less confusion. So a labor certification is not work authorization. It is not the LCA, and it does not convey any legal status. It is no more than stage 1, which allows you to then move to stage 2, which is the filing of the I-140. Okay?